Well, hello, everyone. Thanks for joining us again. We have made it to the end of our legal series webinar. This is session 7, and today we're covering contract negotiation and preparation, employees, contractors, vendors, customers, and I think the list goes on and on. So today we're just going to kind of be doing a little bit of a recap of some of the things that she's discussed in the previous 6 webinars, but also just open to questions and kind of dive a little bit deeper on some of the contracts. For those of you that haven't seen the previous webinars, please do go to our website at grandjunctionsbdc.org/recovery, or you can go to the gjincubator.org website on our resources page, and all of the webinars that we've been doing for the recovery series are on there. So we'll just jump right in with Judith Keene. Welcome.
Thank you so much. It's a pleasure to be back. So for those of you who have not tuned in previously, I am an intellectual property and business attorney in Denver, Colorado, and work throughout the state of Colorado. It is my pleasure to be of use to the Grand Junction Business Incubator and provide some background and experience for new business owners and ongoing business owners in the community served by the incubator, which is pretty large. So without much more delay, there are a lot of kinds of intellectual property we've talked about, and there are various methods used to defend that intellectual property against theft or inadvertent misuse. In order to protect that property, your ongoing diligence is required. You should always take steps to protect both your tangible and intangible property. Just as you would never leave your house unlocked with your car running with the keys in it, you should not leave your inventions and your intangible property without protection. If you have a new invention, investigate whether you might have patent protection available. If you have trade secrets, make sure you take careful steps to maintain them a secret. If you have brand names, make sure you put others on notice of your claim to those brands, and if possible, obtain registration. If you have original artwork, text, photographs, designs, or coding, consider registering your copyright in those original works of art with the U.S. Copyright Office. And be on the lookout for misuse of your property. Now, to protect your property from others with whom you do business, make sure your contracts speak to protecting that property. And with that kind of background, let's talk a little bit about contracts. What makes a good contract? What makes a valid contract? Very basically, a contract is an agreement between two parties that represents a meeting of minds. All that means is you both understand what you're agreeing to. If you don't understand something in a contract, my advice, don't sign it. Get advice, find out what is being said in that contract before you sign it. Because if you're over the age of majority, you will be presumed to have understood what you've signed. Now, a contract should have a minimum of certain specific terms to be a good, valid agreement. I joke that a proper contract is like your 7th grade grammar class. It should have who, what, why, when, and where. In addition, there's some other elements that you didn't learn in 7th grade. Those are how much or what kind of compensation, how do you terminate, and what do you do in the event of a dispute? With these basics, you're over halfway to a good contract. And we'll talk a little bit about each of these. Remember, always talk to qualified legal counsel before signing a document that you don't understand. Once you've read, remember, you're bound to it once you sign it. Now, if you're under 18 and you sign a contract, it's voidable. It's not a valid contract. And so if you are doing business with somebody who's under 18, you need to get their guardian or their parent to sign that contract on their behalf for it to be valid. So let's talk a little bit about the who. Who are the parties? Are they individuals or are they entities? Or maybe both. Maybe you want to have a guarantee by an individual if it's being signed by an entity. If you're contracting with an entity, is it a validly existing entity? If it's a Colorado entity, you can check with the Colorado Secretary of State to make sure that it's in good standing and validly existing. If it's somebody who needs a license, you can check with the state of Colorado to make sure they have that license. I recently ran into that experience. Tried to hire a general contractor who didn't have a license with the state. When I checked, couldn't find one, didn't hire him. What kind of expertise is required? And are you relying on that expertise? If you are, maybe specify what that expertise is. The what. What is being contracted for? And do both parties understand what they're giving and what they're getting? And to whose satisfaction are these duties? Is it to the person who's receiving it satisfaction? Or is it something that you can figure out? Or is it a little bit ephemeral? If it is hard to determine what it is that you're contracting for, how do you figure out the duties? How do you figure out if you're satisfied with it? So be as careful as you can to describe what it is you're getting and how you're going to determine whether it's sufficient. The more specifics you add, the less possibility of a dispute arising. Now, when you're talking about the what, we think about the duties. What kind of efforts are required to fulfill the contract? You often see the words reasonable efforts, efforts as are standard in the industry, or best efforts. They're very different legal obligations with each of those, and best efforts is the highest standard. They're greater than industry standard efforts, and in some circumstances, best efforts may require the person who is providing this work to lose money to fulfill those efforts. So you want to be very careful about whether you're agreeing to provide best efforts. We usually suggest that middle ground of efforts as are standard in the industry is a good place. So when is the contract to be performed? I often find people agree to a contract, but they never put in when things are due. And if you never have when it's due, that contract can go on forever. And nobody wants that. It's good to put in milestones if there are foreseeable breaks in providing something under a contract. For example, let's take coding. If you hire a developer to code for you, you're going to want milestones. When is a deliverable for you to review a draft? When is a deliverable for you to look at the look and feel of that app? When is the final deadline to provide the app? What if there are delays? You want to make sure you put into your contract how to handle that, whether it's both parties have to agree if there's going to be an extension, or if it's a reasonable delay, how to deal with it. For example, what if COVID delayed someone from finishing a project? Well, it makes sense that both parties would agree to extend that contract down the road a bit because of an unforeseen circumstance. There's something called force majeure that a lot of people put in contracts. And a force majeure clause says if there are things outside your control that happen, either party may be able to terminate the contract. Those are very narrowly construed, and you have to be very specific. If you don't put in there that pandemic, epidemics, and work stoppages due to government closures are specifically force majeure, they will be excluded. So force majeure clauses are getting longer and longer with government closures, pandemic, epidemic, public health recommendations, it causes a lot more verbiage required in a contract. So where is this contract being performed? Is it on your premises? Is it somewhere else? It's important to state where it's being performed. One, because you need to know what laws might be applicable if it's in multiple states. And you also need to know what insurance might be required. All right, so that's our who, what, why, when, and where. So now let's talk about how much. This is very important. Everybody wants to know how much they're being paid, when they're being paid, if pricing might change, and if pricing might change, how will it change? Think about now, think about down the road, think about the finalization of your agreement. If you think pricing might change, make sure to write something into your contract. Termination. Everyone goes into a contract happy to work together. And I always joke, you're going into a contract as a marriage. I'm thinking of it as a divorce. So I think about what happens if. Now, the natural termination of a contract is when the work's done. And if you put that into your contract, it's very clear. Most people don't. But I usually suggest when this work is complete and you have accepted it, the contract naturally terminates. There will be some terms that survive termination, and that's kind of a whole other topic, but we can talk about that a little bit later. You also need to think about what happens if one party wants to terminate for whatever reason. They just found they can't do the work. It's important to include some provision on how to terminate. What happens to payments? Are they paid for what they've earned prior, or have they earned nothing because they haven't given a final deliverable? If it's clearly stated, it's not a problem. You can make a decision either way. It's just everybody has to agree. What happens if one party does something wrong? We call that a breach of contract. If one side breaches, it might be a different situation for termination than if the other side breaches. Again, it's a meeting of the minds. If you can agree as to how to handle those breaches at the beginning, when everyone's getting along, it's much easier. It's much more difficult to try to read something into a contract later once you're in a dispute. So disputes, how do you handle that? We usually like to write something into the contract. It makes it, again, much easier. Are you going to give a right to cure? And that means if somebody does something wrong, do you give them notice that they've done something wrong and say you've got 10 days to fix it? If you fix it, we'll just keep going along as if nothing happened. If you don't fix it, maybe there is a liquidated damages provision, which means an amount of money paid, not as punitive, but because it's tough to calculate damages. And that's the amount they pay because they didn't fix it. Now, let's say you don't want to do a liquidated damages. You've given a right to cure. What happens next? I usually write into a contract that the principals will try to have a discussion to see if they can work out the issue. If after a certain specified number of days, let's say 30 or 60 days, they can't decide, then either party can either request mediation, arbitration, or go to court. Mediation is when you have a third party who comes in and listens to both sides and tries to bring both sides to a reasonable conclusion, somewhere in the middle usually. And mediation is not where someone tells you what to do, it's where the parties decide what to do. If the parties cannot reach a mediated resolution, the mediator is not going to tell you what to do. Arbitration, on the other hand, is where a person who's an arbitrator listens to both sides, listens to the arguments, and makes a decision on their own. and makes an order. It's almost like a court order, and it can have the same impact as a court order and can be registered with the court of proper jurisdiction and become an order. A mediation will become a contract if two parties agree to it. And if one party decides to go against that mediation, it's a breach of contract. Okay. Often in agreements, what I will write in is that either party can get an injunction if they need it from a court without discussion. And an injunction is a temporary order from a court requiring a party to stop what they're doing because it's wrong. And you have to show a court that you would probably win in a final court action, and you have enough facts to win in order to get that injunction. It's very valuable if someone's taken your trade secrets or misused your intellectual property, and it's a good first step. If the parties agree to an alternative dispute resolution, the injunction procedure would still be available, and then the parties would either mediate or arbitrate their dispute at that point. And there's a lot of terms we can add into an agreement to deal with that. You can shortcut and reduce your expenses with an attorney if you and the person you're contracting with can sit down and negotiate a lot of these issues about a dispute and how to handle it before you go to the attorney. Then the attorney just puts in the right legal language to reflect what you've agreed to. Now, as part of that process, it's important to think about what law is going to apply. Let's say you have a contract and you're in Colorado and the person you're contracting with is in California. You need to decide whose law is going to apply if there is a dispute. Obviously, it's better to use Colorado. If you're from Colorado, we know what the outcome is more likely to be. We know the case law. And I should footnote that we don't always know what the outcome is going to be, but we have a much better understanding of the case law in the state that we practice. Many times it's the law of supply and demand. If your work is in demand, you have more ability to negotiate whose law is going to apply. If you're the smaller player in a contract, you will most likely have to take on the other party's law as being applicable to your contract. For example, if you're trying to sell an app to Microsoft, I can guarantee you that contract will not be subject to Colorado law. All right, so there's some other issues. Now that we've covered the main issues, there's some sub issues in your contracts that you should always consider. One is insurance. Make sure that whomever you contract with has appropriate insurance, as you would always make sure you carry the right insurance. Is workman's comp required? Is liability insurance for property something that might be necessary? What about personal injury insurance? If this person is going to work on your premises, you want to make sure they have their workman's comp, they have personal injury insurance, and you may want to make sure that you also are named as a third party insured. It doesn't cost anything extra, and it's fairly easy to do, and it's highly recommended. If the other person's insurance is canceled, you will then get notice of it if you are a third party beneficiary to that insurance. Indemnification. People read indemnified language and scratch their heads and have no clue what they're reading. All indemnification means is that if you get sued because of something the person you contracted with did, then that person has to pay everything you had to pay out. So if I have to pay $200 out because of something Laura did to me, and Laura signed an agreement indemnifying me against any liability, she would have to reimburse me that $200. And often you'll see contracts where each side indemnifies the other side for any liability for acts or omissions caused by the indemnifying party. So that just means if Laura gets sued for something I did, I got to pay her. And if I get sued for something she did, then she has to pay me. Okay. And if it's partly her fault and partly my fault, we each pay a portion. Okay. So it's a fairly straightforward payment, but it's difficult language to understand. Without indemnification, you've got another hurdle in the event of a dispute. So I highly recommend that that language be included. Another thought is solicitation and non-solicitation. What if you hire someone to do some work for you and they have access to your vendors or your customers? You want to make sure that they can't then solicit your customers and take them from you after they stop working for you. And that's an important thing in your employment agreements, your independent contractor agreements, and in some vendor agreements as well. If you sell a business, this is particularly important. Your contract should state that you won't go back and take those clients you just sold off to the new company. This will require a reasonable period of time and a reasonable geographic limitation. Another potential paragraph for your contracts is a non-compete. We talked about this a little bit in prior sessions, and I urge you to go back and take a look at the employment section of our first couple of talks. But is this contract a situation where the contracting party will have access to your trade secrets? If it is, you'll want to talk with your attorney about potentially including a non-compete in the agreement. Non-competes are considered void unless they meet very specific requirements. Now let's talk a little bit about intellectual property. This is what we're here for. The two most fought provisions in agreements tend to be indemnification with insurance and intellectual property and ownership of improvements. You want to make sure that you continue to own your intellectual property before the contract, during the contract, and when the contract has ended. That goes for improvements to that property as well. There are times when a contractor will absolutely come up with new improvements to your property. They'll come up with a great idea and they will give that idea to you and you will make the improvement to the property. Without a statement as to who owns that improvement, it's the person who came up with it. So you want to make sure that you have a statement in your non-disclosure agreements, in any contracts that reference your intellectual property, that improvements to your intellectual property are owned by you regardless of who comes up with them. You may also have that same provision for your contractor. That contractor may own intellectual property that they're coming to, and they want to own improvements to their own intellectual property as well. So it's something to really think about. And that's all we're trying to do today, is give you things to think about for your contracts. Now, the end of contracts always have a whole bunch of general paragraphs. Most people don't read them. I urge you to read every word of every contract. The general terms are as important as the rest of the contract. The reason they are there is because through case law, and lawyers have found that without these statements, all havoc breaks loose if there's a dispute. We need to specifically state if somebody is an independent contractor. We need to specifically state that this is an entire agreement of the parties and that other verbal statements are not part of this agreement. We need to state that this agreement can't be modified unless it's in writing. Now, oddly, that particular statement, you can orally agree to modify that statement. So there's some oddities to some of this, but read the general terms. If there's anything you don't understand, ask a qualified attorney. Those general terms, as I said, are based on case law that has occurred over the years.
So Judith, if there's been a delay, like you mentioned earlier, a big one, not 10 days, but a COVID something, would you recommend that people at that point, if they're saying we're looking at 6 to 9 months before we think we're going to be able to continue to do this job, that they go back and revise the contract in writing?
Absolutely. What I suggest is that people prepare an addendum.
Addendum.
An addendum to the agreement that simply says all the terms of the agreement are still valid except as modified in this addendum. And then the things that need to change, like a delivery date, are specified. Maybe the force majeure is changed to state that, we're going to include that each of us can terminate if COVID goes on for another 3 months. If it's a lease, maybe it's that we can put off making monthly payments on our lease until we're able to reopen.
Mm-hmm.
And we'll tack those lease payments that we weren't able to make at the end. So the
Sure.
lease ends up longer, but you're not paying lease payments while you're closed.
Okay.
And keep in mind in that lease situation that the landlord usually has a mortgage to pay too. So it's good to try to negotiate some payment if you can during this time. But I've seen a lot of negotiations and reasonable discussions between landlords and tenants because of COVID and modifications of lease agreements.
Thank you.
Okay. So who are the kinds of people you're going to enter into agreements with? In most cases, your employees in Colorado are considered at will, which means they can leave anytime they want and you can fire them anytime you want. But if you have employees with more responsibilities or higher level employees, you will probably want to have employment agreements with those folks. You'll want to set out what their duties are, what their pay is. Do they have options for shares? Are you going to have a non-compete with those higher level employees because they have access to your highly confidential and trade secret information? Independent contractors always have a written agreement with an independent contractor. Just no other way around it. You want to make sure they have insurance, that they understand they will not be getting any benefits, that they're responsible for their own taxes. And you'll want to clarify how satisfactory performance is measured. Your vendors. In some instances, it'll just be a purchase order. In other instances, you may need a more complicated agreement. If they have access to your premises and your tangible or intangible property, you want to make sure they signed a non-disclosure. Do they have insurance? Is timeliness of their deliveries an issue? There's a statement, time is of the essence, that we often add to agreements, and it has great strength in the courts. And it means that the deadlines in this agreement are hard. Okay. Your customers. Often you will want to have a written agreement with your customers. It may be if they don't pay, you have a security interest in the property you've transferred to them. You want to make sure that if you give them something that if they take apart and reverse engineer it, it could cause you damage. Maybe you have a contract that says you don't have a right to reverse engineer. Are there any warranties? Are there limitations on warranties? What do you do with returns, refunds? Are they allowed to bring a class action dispute? Who has standing to bring a claim against you? If they sell the product 3 times, does that person 3 times down the road have a right to sue you? We often write into customer agreements that only a customer with proof of purchase has standing to sue, and that they're not permitted to bring class actions with other customers. If you are licensing your tangible or intangible property to someone else, you will want to have a careful written agreement. You will want to have the right to inspect any licensed use. And if the licensed use doesn't comply with your requirements, you'll want to be able to request alterations to that use. And you'll want to be able to terminate those licenses if they misuse. Make sure any license is limited to the smallest use necessary. Don't give more than the person on the other end needs. You might also consider a liquidated damages provision in the event of misuse, because damages are very difficult to calculate and expensive to calculate. For example, photographers often say, if you use our photograph, it's $1,500 for licensed use and $2,500 plus our attorney's fees and collections costs if you misuse it. And if those are in online terms and conditions and you download somebody else's photograph, you are bound by their online terms and conditions. Online terms are a contract. All right. A privacy policy online is also your contract with users saying that you're going to comply with the privacy rules that you state. And while privacy policies are a whole other topic for a whole other seminar, I urge you to get familiar with the issue. You should have terms and conditions on your website for giving users limitations on using your site. And you should have a privacy policy that describes what efforts you take to maintain user information as private. If you monetize your customers' information in any way, example, you sell a mailing list, you're going to need to make sure you comply with the most restrictive state privacy policy rules in the country. And right now that would be, in my opinion, California. I haven't made a study of every state's most recent laws, but California has some pretty detailed privacy regulations. And Colorado has privacy regulations as well. They're not as strict, but that you should familiarize yourself with them. If you sell in Europe, there are privacy regulations in the European Union and the European Economic Area that you are required to comply with. And you may also be required to have business partners and your contractors comply with those privacy policies as well. So I know we're a little over, but to recap, I suggest that you audit your customer, employee, contractor, and vendor agreements. Do you have non-disclosures in place? Do employees understand what is your property and what they can and cannot do with your property? When someone leaves, do you make sure they haven't walked away with your property? If you have trademarks, make sure they're available for use. Make sure you're not accidentally using somebody else's trademark. If it's registrable, consider registering your trademark. If it's not registered, make sure you put a TM next to it so that others know you claim it as a trademark. And remember, use it as an adjective, not a noun. Your misuse or others' use without your permission could cost you your trademark. If you have original copyrightable materials, get them registered with U.S. Copyright Office within 3 months of publication for best protection. And if you permit user content to be posted on your products or your site, make sure you speak with legal counsel about complying with the U.S. Digital Millennium Copyright Act in order to gain safe harbor in case those users post infringing material on your sites. Review your websites for use of trademarks, possible copyright content, and inadvertent disclosure of your trade secrets. And make any terms of use, privacy policy, and any copyright policy clickable links on the footer of every page of your site. Trade secrets, if you've got them, protect them. Keep them secret. Maintain visitor logs on entry to your office. And don't allow entrance to areas where trade secrets are located unless people have a requirement to need that information. Have a trade secret policy and educate your employees on a regular basis. Take steps and watch for misuse of your property by third parties. And enter into contracts that clearly define what it is you own and how you protect that property. Value your own property and take care of it. And with that, I think we have closed out our 7th seminar.
That was fantastic. Yep, that is such good information. And I do want to mention to everybody some of the things that Judith just touched on: trademark, trade name, those kind of things. She specifically did webinars throughout this series going a little bit more in depth than those. So I encourage you, if you do have questions about those, to go back and view some of those webinars that, as I said, again, we have on our websites. And we do want to make sure that we let you know that Judith, though she is an attorney, she's providing this information for us. It's certainly important to make sure that any contracts or anything that you're doing, you're actually getting legal advice from your attorney before we do that. One question I had is, are there general contracts available out there? I would assume there are, that give you a place to start, and then you can kind of go through and modify what you need for your particular situation? Or do you recommend, what do you recommend?
Well, this is a tough question. And obviously, the first recommendation I have is seek qualified legal counsel for any contract. I will say the internet is what it is, and you can find almost anything on the internet. And there is no review of those documentations on the internet, and the quality control doesn't exist. And the bane of my existence is when people say, oh, I downloaded this from the internet, won't this work? And I review it, and yes, there's some that will work, and most is complicated and doesn't work. Contracts are not forms. They're unique to each person's situation. And while a non-disclosure agreement can be more formulaic than many things, most contracts are very individualized. I have never written the same contract twice in 34 years.
That's good to know. Yeah.
And I will add that even though we started the seminar with this, everything here is for information only, and it is not legal advice. And so if you have a particular legal question, always speak with legal counsel. I am always happy to have an informal conversation with somebody to give a little bit of information. I don't charge for initial consultations. If somebody is listening to this and has a particular question, I'm always happy to help Grand Junction Business Incubator out and give a little bit of free advice. So don't hesitate to call if you're concerned, and we can always help hook you up with an attorney to help in your particular situation.
Well, we're closing out 2020, Judith, and I just want to say thank you so much for all the information you've provided over this 7 series, legal series that we have. SBDC and the Business Incubator are just so grateful. She has done this free of charge for us, has taken time out of her busy schedule to provide this information. So we're just so thankful. And we will definitely be touching base with you in 2021, because I think as we move forward, small businesses are going to have new issues that are going to be coming up that we're going to want to address. And so we definitely will reach out to you when we get there. But thank you so much, and happy New Year to you.
And a happy New Year to you and everybody who picks up on this recording, and take care. Let's hope for a calmer 2021.
Amen. Thank you. Bye-bye. Bye, everyone.